Okay, we have our first decision of the day, and the Supreme Court just handed Trump a massive win. This is the case that everyone has been calling the birthright citizenship case, but the reality is they don't rule on the birthright citizenship issue. This is really about nationwide injunctions, but it's still a huge win for Trump. I'm Eliza Orland's career public defender for 15 years in Manhattan. All right, let me explain. Now, the court did not rule on whether or not Trump's executive order violates the 14th Amendment. Instead, they focused on how far courts can go when blocking federal actions. Essentially, what the court said was federal courts do not have the authority to issue nationwide injunctions. So they ruled on universal injunctions, meaning they can't block a policy from taking effect for the entire country unless it directly involves the parties in the lawsuit. So what does this mean? Well, it means the injunctions issued in this case only apply to these specific plaintiffs. And it means the rest of the policy can go forward elsewhere unless someone else sues. This is unfortunately a massive win for Trump because nationwide injunctions have been a critical check on the Trump administration in that courts have been able to stop him from implementing these policies nationwide that are truly harmful. Don't let anyone tell you that they ruled on the constitutionality of birthright citizenship because that did not happen. But by limiting who courts can protect, it definitely made it a lot harder to stop them. Okay, we have our second decision of the day on this blockbuster day of Supreme Court decisions. It is good, but not great. With this Supreme Court, we will take good. This is the one about whether your insurance has to cover preventative care, things like PrEP, cancer screenings, birth control, etc. And the good news is that the Supreme Court said that they were declining to block the Affordable Care Act's preventative care requirements nationwide. So this means for now, insurance companies will still have to cover things like PrEP, contraception, and cancer screenings. But the reason why I say this is good and not great is because this is not an actual ruling on the merits because they're sending this back to the lower court. The Affordable Care Act's mandate survives for now, but the court left the door open for future challenges. The stakes are huge. If these mandates were to fail, there would be millions of people who could lose their access to the most basic and life-saving preventative services. This isn't over, but it's a reprieve, and so we'll take it. In our next decision, we actually have a surprise win. In a 6-3 decision, the Supreme Court upheld a federal program that helps low-income communities, schools, and rural areas access phone and internet. Here's what happened and why it's such a big deal. The case was consumer research versus the Federal Communications Commission, the FCC. In this case, the challengers argued that Congress gave too much power to the FCC and to a nonprofit called the Universal Service Administrative Company, which manages the Universal Service Fund. That fund helps pay for broadband in places that need it most: schools, libraries, rural communities, and places with low income. It's funded by telecommunication companies under the 1996 Telecommunications Act, and those costs are often passed on to customers. The plaintiffs claimed that this setup violated the non-delegation doctrine and Congress gave away too much of its legislative power. But the Supreme Court disagreed. In a majority opinion written by Justice Kagan, the court said the structure is constitutional and the FCC can continue running the program as it exists. Justices Gorsuch, Alito, and Thomas dissented, arguing that the FCC and the USAC have too much unchecked power. Now, why this matters. This case was part of a broader push to gut federal agencies and limit federal regulatory powers and limit public programs. If the challengers had won, this could have dismantled broadband access for millions of people and set a very dangerous precedent about how the government funds public services. Today's ruling is a rare win for digital equity, for the administrative state, and for the communities that depend on access. Well, we just got a horrible decision, and as Justice Sotomayor says in her dissent, this may end public education as we know it. The Supreme Court just handed a major win to religious parents who sued the public schools in Montgomery County, saying that their child should have the right to opt out of any education regarding LGBT inclusive texts on the basis that it violated their First Amendment rights. This is a huge shift and a devastating one, and we have to talk about this case. In Mahmoud v. Taylor, the Supreme Court ruled 6-3 majority opinion written by Justice Alito that religious parents in Maryland are entitled to a preliminary injunction, meaning the school must pause the enforcement of its inclusive curriculum for now. The families argued that having their children be required to attend lessons that involve LGBTQ themes violated their First Amendment rights with regards to their free expression of religion, and the court agreed, at least enough to stop the curriculum while the case continues. But Justice Sotomayor issued a scathing dissent. She was joined by Justices Kagan and Jackson. She warned, "Today's ruling threatens the very essence of public education. The court, in effect, constitutionalizes a parental veto power over curricular choices long left to the democratic process and local administrators. That decision guts our free exercise precedent and strikes at the core premise of public schools, that children may come together to learn not the teachings of a particular faith, but a range of concepts and views that reflect our entire society. Exposure to new ideas has always been a vital part of that project until now. The reverberations of the court's error will be felt, I fear, for generations." Unable to condone that grave misjudgment, I dissent. Whew. Now listen, the case is not over entirely, but the court signaled strong support for allowing religious opt-outs even in public education. That could reshape what is taught in schools across the country. And who gets to decide? Well, the Supreme Court just ruled that if you want to view adult content online, that's okay as long as you show ID first. Yep, we just got the decision on Free Speech Coalition versus Paxton, who's the Attorney General of Texas. And Texas basically implemented an age verification law to view websites with adult explicit content. And the Supreme Court upheld that law. This has way broader implications than just that. Let's talk about what this means. This decision could reshape online privacy and free speech across the country. This law was challenged under the First Amendment, and the court ruled 6-3 and sided with the state of Texas. Justice Clarence Thomas, writing for the majority, said that protecting minors from sexually explicit content justifies the burden the law places on adults. The ruling affirms the lower court decision that didn't apply strict scrutiny, the usual high bar for anything that implicates speech, and instead applied a lower level of scrutiny called rational basis. This decision is not happening in isolation. There are 24 states that have passed age verification laws that were waiting on this decision, and many had been blocked by lower courts for threatening privacy and speech. Justice Kagan wrote the dissent, joined by Sotomayor and Jackson, in which she warned that this ruling could chill lawful expression and hand states massive amounts of power to police digital spaces. Why this matters? Well, this ruling could have huge impacts on not just porn, but it could pave the way for ID checks and age verification for access from everything to reproductive health, LGBTQIA issues, and even political dissent, anywhere states claim they're protecting children. This ruling rewrites the rules of online freedom, and the consequences will go far beyond this one industry. In a final surprise of the morning, when we were expecting 6 decisions, the Supreme Court declined to rule on the Louisiana redistricting gerrymandering case. Instead, the Supreme Court kicked this case to the next term, which is very surprising. And I want to break this case down for you. In this case, the court was expected to decide the fate of the new congressional maps that had been drawn by the Louisiana legislature back in 2024. The map added a second majority black district after a lower court found that the old one, which only had one majority black district, likely violated the Voting Rights Act. But the challengers sued, saying that the new map was too much based on race and therefore was unconstitutional, arguing that the fix was a racial gerrymander. Today, instead of issuing a ruling, the Supreme Court said that they wanted to hear additional arguments. So the case will be re-argued next term, but this signals that the court might be looking to issue a much bigger ruling, and it could gut the Voting Rights Act. We'll note that Justice Clarence Thomas dissented, calling the Voting Rights Act broken beyond repair, and arguing that the Constitution should trump any effort to enforce racial fairness in voting. The fact that we got no ruling is a huge indicator that the court intends to do something massive next term. This case could end up redefining whether race can be used at all to correct racial discrimination in redistricting. And the outcome could radically limit the Voting Rights Act going forward. Well, this wraps up, I think, all of the major decisions that were coming down today. There is still an emergency docket, formerly known as a shadow docket. So we do have other, but make sure you're following for more because there are still decisions to come that are on the emergency docket, formerly known as the shadow docket, such as the reduction in force decision and some other ones. So please stay tuned for more. I will be breaking it all down for you. And thank you for being here. Leave questions in the comments if you have them. The fight goes on.